A man who was charged with violating the Gun-Free School Zone Act has had his charges dismissed with a catch. Hello everyone and welcome back to the channel. I have another good news update today, which marks several in the last few weeks, each one very welcome. This one involves the case of Gabriel Metcalf of Montana, who I covered extensively on this channel. I will link all of the previous videos down in the description, but the most bare bones explanation is that Mr. Metcalf lived with his mother in a home that just so happened to be inside a school zone. An ex-neighbor who had harassed and threatened the Metcalfs was allegedly violating a restraining order by continuing to go by the property, walk in the alley next to the home, and even pepper sprayed Metcalf in the face. Metcalf tried to report it, and the cops told him that he needed photographic or video evidence. Fearing for his and his mother's safety, he took to carrying a single-shot shotgun while in the yard, and sometimes while running outside to get video or photo evidence of the ex-neighbor driving by the home. This ex-neighbor, by the way, was so nuts that the cops didn't even want to deal with him. Now, parents dropping their kids off at school or picking them up saw Metcalf, called the cops, and the cops said, hey, nothing we can do. They visited Metcalf a few times to tell him that he was making parents nervous, but said that he had not broken the law. Unfortunately, Metcalf got annoyed by the cops visiting and made the mistake of calling the feds. Next thing he knew, the FBI and ATF weaseled him into admitting that he carried his gun while escorting his mother to work, and then he was charged with violating the Gun-Free School Zone Act. Now, before I get into the rest, this video is brought to you with the help of the Attorneys on Retainer program from the Attorneys for Freedom. Just like the name says, the folks with AOR are actual attorneys there to help you when you need it most. I have covered so many self-defense stories on my channel that end up with gun owners having to fight in court, and if that ever happens to you, you do not want to go it alone. Just look at this case. The guy never even shot his gun and he got hit by the feds. Now, AOR specializes in self-defense incidents, and a call to their hotline gives you immediate, direct access to an attorney who starts on your case on the spot. It doesn't matter if you were in a gun-free zone, if it's a no-knock raid, if you get hit with felony charges, or were even technically a prohibited person. So long as you were a member at the time of the incident and acted in good faith, they will take your case and give it their all. They even cover appeals, bail bonds, and red flag hits. So to get an entire firm of attorneys in your corner, head on over to the link down in the description and use code LibertyDoll to get $50 off your individual sign-up. Back to Metcalf. He has been fighting this in court for literal years. He ultimately pled guilty in a deal that would allow him to file to dismiss his indictment. He filed a motion to dismiss back in September 2023 based on the fact that he had a gun license, and Montana has a law that exempts those with gun licenses from the Gun-Free School Zone Act. He was denied, and in August 2024, he was sentenced to 3 years probation and, due to the felony conviction, became a prohibited person. He filed an appeal 4 days later. As per state statute, Montana Code Section 45-8-360 provides that, in consideration that the right to keep and bear arms is protected and reserved to the people in Article 2, Section 12 of the Montana Constitution, a person who has not been convicted of a violent felony crime and who is lawfully able to own or to possess a firearm under the Montana Constitution is considered to be individually licensed and verified by the state of Montana within the meaning of the provisions regarding individual licensure and verification in the Federal Gun-Free School Zones Act. Not to mention the fact that he was on his property, though there has been argument as to whether or not he crossed from his yard into the sidewalk around his property, and again admitting that he had his firearm while he brought his mother to work. He also argued Second Amendment grounds in that he didn't get appropriate notice to be convicted. The district court declined to dismiss his indictment. Meanwhile, that crazy neighbor, convicted of violating the protection order, felony level. Metcalf appealed the decision in his case, landing it with the Ninth Circuit Court of Appeals. In a 2-1 decision, a 3-judge panel reversed the court's denial to dismiss the indictment. But, as I said in the opener, there is a catch. The judges punted the case back to the lower court, ordering them to dismiss the case, but not on any Second Amendment grounds. They ruled simply that the case should be dismissed based on a lack of fair notice. Another question here was not whether or not Metcalf was licensed, but whether or not the Montana licensing procedures satisfy the requirements set forth in the Gun-Free School Zone Act. Writing for the court, Judge Van Dyke noted, "The Gun-Free School Zones Act accepts from the Act's broad prohibition individuals who hold a license by their state, if before an individual obtains such a license, the law enforcement authorities of the state or political subdivision verify that the individual is qualified under law to receive the license." The decision says that the judges don't argue that he was legally licensed, and thus that Montana law applies to him. They then said that applying the traditional schools of statutory interpretation, they believe that Metcalf's license did fall within those parameters, and thus he lacked the appropriate notice to be convicted of violating the Gun-Free School Zones Act. Continuing on with his conviction, they said would be inconsistent with the principles of fair notice and of not punishing innocent behavior. Again, no Second Amendment grounds, nothing based on the fact that the Gun-Free School Zone Act has been found unconstitutional in the past. The dissenting judge, Judge Schroeder, wrote that she believed everyone actually agreed with her and were simply misinterpreting the statutes and Constitution in order to make a special exception for Metcalf's case because he made a good victim, which is an interesting take. She argued that his conviction, especially getting only probation, was fair. She argued that the only reason the cops didn't arrest Metcalf and left it to the feds was because they did not have the authority to do so. She then says that the only reason the case is being dismissed is because the lack of fair notice is being applied because the cops didn't charge him with violating any state laws. She then said that the ruling would allow him to get his gun back and continue terrorizing his neighbors. You may or may not be able to hear Liberty Toddler disagreeing with that judge's opinion. We just had tubby time and the bathroom is directly next to this room. I would argue that if the cops repeatedly told him he wasn't breaking the law, and if state law said that he wasn't breaking the law, it was reasonable of him to assume that he was not, in fact, breaking the law. And the feds, well, never trust a fed. Now, it's entirely possible that the feds will argue against this decision, but at this point, Mr. Gabriel Metcalf has had his conviction dismissed. All right, ladies and gentlemen, that is it for this video. You guys know the drill. For all of the algorithm things, please do them. And as always, thanks for tuning in. Stay safe out there and happy shooting.